Like Megan said, my name is Thomas Nichols. I'm the Director of Advocacy and Legal Services here at Disability Rights Arkansas. We are a federally funded organization made up of lawyers and advocates who investigate abuse, neglect, and exploitation and represent individuals with disabilities in um, lots of different areas, such as Medicaid access, rights under guardianship, access to vocational rehabilitation services, and removal of barriers to employment for Social Security recipients, among other areas. And so we have a very live practice when it comes to guardianships, naturally. And so I'm just going to kick it off. When speaking on guardianships, it's important to consider it as part of this continuum of decision-making supports. It is a spectrum that begins with decision-making on your own, individual decision-making without support, and it ends with the complete removal of the ability to make your own decisions on virtually any matter on a permanent basis. As you can see, there are more than two options. So jumping directly from making your own decisions to permanent plenary guardianship might not be the best option for everyone in every circumstance. With options such as the use of less restrictive alternatives, such as supporters through supported decision making, powers of attorney, representative payee, surrogate decision makers, and temporary or limited guardianships, there's plenty of room for the consideration of an individual's specific need for support. I am going to try to get all the way through this presentation. However, it is a very long presentation. There are lots and lots of slides, and so there is just no conceivable way I will be able to make it through it. I'm going to put the less restrictive alternatives towards the end. There's a lot of information on it on your PowerPoint. I know Megan has shared the PowerPoint with you all. Let me pull up the chat. Oh, very good. Thank you, Megan. So the origins of guardianship, this concept that we have of guardianship can be found as far back as Roman law, perhaps earlier, and it derives from the state's parens patri authority. Parens patri literally means father of the country. Originally, guardianship had two purposes. First, to prevent the public from bearing an obligation to care for the population of those who we would consider to be eligible for guardianship, and to ensure property and assets are protected for heirs. Since then, it's kind of evolved away from that into more of a consideration of whether the individual themselves is actually eligible and can make decisions and communicate decisions in order to meet the essential needs that they have, and less about protecting inheritance for heirs. Heirship was paramount when this concept was established. Guardianship has qualities that might make it more preferable than some other options. They offer some protections against abuse or neglect. An official designation as a guardian carries obligations to report to a court with jurisdiction over the guardian. There are standards in the law such as a fiduciary duty, and some clarity on specific decision-making authority and decisions that do or do not require court approval. It reduces ambiguity about who can or cannot make decisions. Some of the other less restrictive alternatives on the continuum of decision-making can be revoked at any time and can lose authority without that third party having notice. Here, where we have a guardian who has been appointed by a court, there would be an easy way for a third party to be able to validate that individual's decision-making authority by looking at the pleadings that are available to them in the court to see if they've been removed or if their guardianship is still active. And so reducing ambiguity is something that we as lawyers like. We love predictability, right? We want to make sure that there is a person who is authorized to make those decisions, and third parties uh, uh, would be able to rely on guardians with much more validity than, say, relying on something like a power of attorney or an individual who may or may not be under a guardianship who purports to have their own decision-making authority. There are some less appealing aspects of guardianship. Um, from the individual's perspective, it could be the loss of legal personhood, right? It's often referred to as civil death, right? According to the law, you don't have the right to make decisions about yourself, about where you live, about who you associate with, whether you want to purchase something, whether you do or do not want to take particular types of medication or engage in certain activities. They also lose the right to experience what we call the dignity of risk. Um, we learn from risk, and it's a very crucial part of human development. There can be, unless the guardian allows it, there can be no opportunity necessarily to try new things, to test limits, etc. Who is eligible to be under a guardianship? So we've abandoned some of the more archaic or inappropriate terms such as incompetent and insane in favor of the term incapacitated. That happened uh, about a decade ago. Uh, I think that's important to note because incapacity does not necessarily mean it is a global incapacity. It doesn't necessarily mean that it's permanent either. One can be incapacitated on a transient basis. For example, many of the apparent impairments that are listed can be cured, treated, or even ameliorated, uh, sometimes with the use of less restrictive alternatives to guardianship. But uh, really, you have to meet one of these categorical areas for incapacity. Do you have a mental illness? Do you have a mental deficiency? Do you have a physical illness, a chronic use of drugs, or chronic intoxication? And then, do you then lack the understanding or capacity to make or communicate decisions to meet the essential requirements for health or safety or to manage your estate? So it's not enough to simply have an impairment. You then also have to lack the ability to make or communicate decisions that would be necessary for you to make healthy, safe decisions. Different types of guardianships. We have guardianship of the person. Um, that is just guardianship over an individual's own health care, where they live, who they associate with, etc. Um, Guardianship of the estate, that is just dealing with finances, assets. It can be managing Social Security funds. It can be managing bank accounts, trust accounts, etc. You can either be the guardian of the person or the estate or both. We call guardian of both the person and the estate a plenary guardianship, right? It is global in nature. You can also have limited guardianships that can be limited in time or in scope. You might only need this, assistance with making healthcare decisions, right? Or you might not be able to make healthcare decisions on your own, so you need a guardian of only healthcare decisions. But say you're able to manage where you live, who you associate with, etc. You might have only a guardianship of your healthcare decisions. You can be limited in time. It might be that you need a guardian while you are recovering from a physical illness. And so someone jumps in and acts to make decisions on behalf of that individual. And after they have recovered, they no longer require a guardian. Or you can have one that's on a permanent basis. Rights that are impacted by guardianship under the law, voting is one. You, by default, do not have the right to vote unless the court orders otherwise when guardianship is granted over you. That it used to be the opposite. Instead of seeking court approval to allow someone to vote, about 20 years ago, they changed it. And now, by default, you may not vote unless the court approves it. Marriage and reproductive rights, exercising any of those requires court approval. Where you live, where you travel, all of those are decisions that a guardian would be able to make for you. Access to money, healthcare decisions, your right to contract, etc. It really touches all aspects of life. Guardianship usually begins with a temporary guardianship. Changes in the current legislative session added some clarifying language regarding emergency guardianship. It allows for guardianship to be established on a 14-day basis, and it really just clarifies that emergency guardianship can be established immediately. And then it appears that at that point, after 14 days, you have to have a hearing to establish the temporary guardianship for no longer than 90 days, subject to an extension. You can get a temporary or emergency guardianship based on there being an imminent danger to the life or health of the incapacitated person. If there's the likelihood of loss or damage or waste to the property. The court can grant an emergency or temporary guardianship with or without notice. And again, a hearing would have to happen within 14 days with meeting the notice requirement. However, and I will repeat this later on, if you cannot get service on a ward, you are required to at least make a good faith effort to do that, be reasonably diligent in trying to serve them before that hearing. And then if you are not able to get them served, it does not prevent the court from granting guardianship, but you then, after the hearing happens, have to continue trying to serve them after that temporary guardianship is granted. Temporary guardianship, again, cannot exceed 90 days, can be extended, however, by the court beyond that, either with court approval or by agreement between the guardian and the ward. Outside of a temporary guardianship, it really at any time before a temporary guardianship has become stale and terminates on its own, or without a temporary guardianship having been established, if the prospective guardian has all of the evidence that they need in order to establish a permanent guardianship, they can file for one of those at the outset or along the way while they are a temporary guardian. In finding that a person needs a permanent guardianship, the court has to render findings of fact, not only that the ward is incapacitated, but also that the ward needs a guardian. One can be incapacitated and might not need a guardian. In doing so, another statute also requires the court to determine the extent of the incapacity, what areas it covers, and the feasibility of less restrictive alternatives. So something we see that, at least in our practice, that gets overlooked a lot, and it's not necessarily to say that it happens often in guardianship cases, but happens often in guardianship cases that end up coming to us, is this focus on the feasibility of less restrictive alternatives. And what might be a dose of prevention for that is going through some of the other less restrictive alternatives in in presenting evidence and why those less restrictive alternatives might not be feasible. When establishing a permanent guardianship, the court has to determine whether it needs to be general or limited in nature. Is it going to be one of these plenary guardianships of the person and the estate? Is it going to be for all areas of the person and all areas of the estate, or are we going to leave some areas for the proposed ward to make decisions on their own? Rights of a proposed ward as part of the due process that's afforded to them. They attach prior to guardianship, right? As soon as a petition is filed, you have to serve them with notice of any hearings that happened, whether it's an emergency or temporary guardianship or a permanent guardianship. And like I said before, notice, if not effective, as long as there is a reasonable, diligent effort to get notice, the court may go ahead and award a temporary guardianship, but you still have to make those efforts after the hearing as well. I believe that was one of the changes that occurred in this previous legislative session. Ward has the right to respond, right? Fair notions of due process. They have the right to notice and an opportunity to respond. If the ward wants to appear at court and object, then they absolutely have the right to do that. They have the right to counsel. That's not necessarily the right to appointment of counsel. We have rarely seen appointed attorneys in guardianship. Some other jurisdictions actually have very specific standards for appointment of attorneys for representing proposed wards and guardians. Uh, some even appoint attorneys to represent wards in every guardianship. We do not have that here. I don't know if this is still good law, but at one point, the public defender statute had within it, among their duties, was representing individuals proposed for guardianship. As part of this due process, the statute, you have to have supporting evidence. We will get into what that means. It includes evaluations, and it has a very high standard of proof. Evaluations are another area that it will get overlooked a lot. They have to be within the last 6 months. It's very specific on what evaluations must be evident in a guardianship case. The 6 month one, the 6 month requirement, you cannot have an evaluation that is 5 years old, and should not expect at that point for it to be anything other than informative, but it cannot be the basis for this consideration of whether the individual right now needs a guardianship. It has to be conducted by a professional, and that's defined in the law, a professional with expertise. I believe it needs to be either a psychologist, a medical doctor, or a licensed clinical social worker. It has to include information about the medical and physical condition of the ward. Has to include an evaluation of the ward's adaptive behavior and their intellectual functioning. That's IQ, and adaptive behavior means how they function. It can include a component of their emotional regulation skills. It can include their ability to adapt to their environment. And it has to include recommendations of not only the specific areas that the person needs assistance, but also that important point that I brought up earlier, the least restrictive alternatives that are available and whether or not those alternatives are feasible. Duties of the guardian. So let's assume that you're now a guardian. What do you have to do? Well, one statute says you have to care for and maintain the ward. That just regards the person. If the ward is a minor, you have to see that he or she is properly trained and educated and has the opportunity to learn a trade, occupation, or profession. So you have to have them get properly educated, and you have to give them some type of opportunity to be able to work and earn a living or be trained to work and earn a living. When it comes to guardianship of the person, again, it is substituted decision making about everything except the property that belongs to the ward. Same statute, but the section on guardian of the estate. This one has more specific duties. They have to exercise due care to protect and preserve property. They have to invest and apply property in accordance with the law. They have to account for the property unless the court orders that they do not have to. So the default is they have to file accountings, and they have to return the property to the ward when they are removed as guardian or when the guardianship terminates. They have a fiduciary duty, and in doing that, we have to apply the law of trusts by law. How can the court exercise oversight? So one of the benefits to guardianship, as opposed to one of any of the number of less restrictive alternatives, is that we do have this element of court oversight, right? If you have a power of attorney, for example, the courts don't generally exercise oversight of a power of attorney unless something goes terribly wrong and it results in a different type of jurisdiction, civil jurisdiction when those are litigated. Here we have the probate court, by virtue of their being a guardian, has oversight. They can do it at the beginning. Something I didn't include in this, just by ensuring that the proposed guardian has met their burden of proof and has all of the evidence needed in order to get a guardianship in the first place. When a guardianship is established, it can be with a bond. If the court chooses to institute a bond or require a bond from the guardian to ensure that they exercise due care with respect to the ward's property. Once a guardianship is established, the guardian has to do an inventory of the ward's property if it's a guardian of the estate, right? So we need to know how much the ward has before the guardian takes over so that we know along the way whether they are accounting for that property when they file their accountings or at the end of the guardianship. So every year, the court may exercise oversight by reviewing those accountings either of the estate or of the person. Not really called an accounting of the person, but it operates the same way. You are telling them the nature of the ward, how they are, how is their health, where are they living, how are they adjusting, do they have any difficulties with things that are associated with the person of the estate or the person of the ward, as opposed to how am I managing their accounts and their property. And then along the way, the court may request a review, may request a hearing. Usually those aren't going to be court initiated unless an accounting is not filed or there's not an inventory that is filed. They will nearly always have a review hearing when someone notifies the court that there is an issue with the guardianship or if an accounting is not timely. I have even seen a court just sua sponte terminate a guardianship when an accounting was not filed. So a few years ago, there was a large rewrite of a component of the guardianship statutes, the guardianship code. In that, they implemented what's called the Ward's Bill of Rights. It is a series of rights that has to be served on the proposed ward, along with process, along with the requirement to provide notice of the guardianship proceedings against them and notice of any hearings. So along the way, the ward should receive at least a couple of copies of the ward's Bill of Rights and has access to it at any time that they request from the guardian. They have all the rights that aren't expressly limited by the court. Of course, if you have a plenary guardianship, just an order that says may not exercise any rights other than those not limited by the court. If the court doesn't is global in their orders, then that leaves few civil and legal rights left for the ward to actually exercise. They have the right to appropriate communication and visitation with persons of their choosing. I have with limitations underlined because this does warrant its own slide and a bit more information, because that is broken down quite a bit in the ward's Bill of Rights. The right to all paperwork associated with the guardianship, so the ward can have access to the accountings along the way, the inventory, all of the pleadings that are associated with the guardianship. They have a right, and this is one that's overlooked a little bit, depending on how involved a guardian is. The right to a guardianship that encourages independence with the goal of termination. Right? Again, guardianships can be transient in nature. The law is written in a way that we would expect to be able to get a guardianship on short notice, terminate that guardianship for a period of time, get guardianship again later if necessary. But if that individual wants it, they have a right to a guardianship that encourages less restrictive alternatives. They have the right to have the guardian consider the ward's personal preferences, the right to exercise full control of aspects of life that's not granted to the guardian. Seems to be a rewording of something on the last slide. Right to information in their native language or accessible form. That might be Braille, that might be ASL, that might be Spanish, that might be any number of different forms. And that information, though it doesn't say, would not be limited to just papers from the guardianship case or those relevant to the guardianship case. That might mean the right to information about their health care and those other personal preferences that the ward might have, so that they can express their preferences. The right to consultation on significant decisions, things like, are we going to move the ward to a different city, a different state? They have the right to be consulted on decisions that are significant in nature. And they have a right to a hearing. If the ward wants a hearing, the ward can get a hearing. And as we'll see, at least with regard to communication and visitation, there is an express requirement for the guardian to assist the ward in requesting a hearing if the ward so chooses. So this right to appropriate communication and visitation with any person of the ward's choice. This law was once different. The family of Casey Kasem, known for weekly top 40 on the radio, experienced a guardianship issue whereby they were prevented from communicating with Casey Kasem at the end of his life. And as a result, they went around the country lobbying for the right to communicate for people who were subject to guardianship. This law was first enacted, I think, about 10 years ago, and it would before require the guardian to petition the court to limit communication. So the onus was put on the guardian, the person who is authorized to make decisions and who is not incapacitated, to go to court and ask the judge if they can prohibit communication with a third party. Now, as of a few years ago, we have flipped this obligation somewhat, at least partially, and placed the onus more so on either the ward themselves or the third party with whom communication was prohibited. So it doesn't relieve the guardian of all obligations. They can't just say, I prohibit communication with the ward, period, end of sentence. They have to, after they determine that the ward should not be able to communicate with a third party, they have to express that decision to the ward and the third party. They have to commit that decision and their reasoning in writing and deliver that to the ward and the third party, along with appeal rights to the court. And then if the ward objects, they have the right to request a hearing, and the guardian must help them arrange for that hearing. So there are decisions that, even though the guardian can make a number of decisions, there are some that require court approval. Abortion, sterilization, psychosurgery, removing organs, withholding life-saving treatment, authorizing experimental procedures, authorizing termination of parental rights, authorize the individual to vote. And I will take a moment to talk a little bit about this one after the end of this slide. Prohibiting the individual from getting a driver's license and consenting to settlement. Okay, you have to have court approval for all of these things. Now, we have seen a bit of a strange thing in the law. You have to petition the court in order to allow a ward to vote. And people can be under guardianships for any number of reasons that might not prevent them from voting. They might be able to voice their opinion with no problem, and should have the right to vote. But there is no standard for what the court ought to consider, or how much information the court would even need or should have available to them in order to authorize the individual to vote. Fortunately, we have not found a court to be uh, uh, unreasonable or anything other than absolutely open to someone expressing their clear desire to want to vote. And it has been more uh, uh, um, formality than anything getting that authority. But I would urge you all, if there are individuals who are going under guardianship who it is important to them that they be allowed to vote, things that are often not understood by guardians is that if you're under a guardianship, you do not have the right to vote by default. And so, if that is something that the guardian and the ward want to persist after they get guardianship, best time to do that would be to do it on the front end, and ensure that in your pleadings and in the court's order that it continues the ward to be authorized to register and vote. I'm going to go back and look at some of these questions. Serving a parent notice of hearing when whereabouts unknown, is it enough to verify unknown whereabouts after diligent inquiry in the petition? Hmm. I think you would still, and I don't know if this has been clarified in the law. This is not something I've encountered before. You have to make diligent effort. There are people that you have to serve, but I do think that in those circumstances, you would have to go to the court, um, explain the situation, and as long as the court relieves you of that obligation, doing it on the front end would be important in the petition. But I think that you would still have to try to get them served somehow. I just don't know whether you would be required to do a warning order, but I suspect you might, if it's a parent instead of the individual themselves. I found attorneys not serving the word properly, only service of notice of rights before he's uh, I don't know if that's a misprint. Only service notice of rights, especially in cases where parents are seeking guardianship of an incapacitated person. Yeah, invalid service might be grounds to overturn a guardianship, perhaps. Um, as long as there is diligent effort beforehand. Uh, I don't know that with the new changes that are happening in the law with this last legislative session on allowing people to continue trying to serve after the hearing happens, it might be overlooked. Um, it raises a lot of questions of whether the evaluation would be stale by the time the service issue is brought to the court's attention. So very interesting. I don't have a great answer on that one. This one just says service on adult putative ward. Award of attorney's fees and definition of bad faith and actual malice and statutory citation. Just a question on that. Oh, what are the definitions of bad faith and malice in 2865 111? I don't have that as part of one of my slides. We don't we don't usually request attorney's fees in guardianship cases, except in special circumstances. So we've not done it in the past 10 years. I don't have any experience in that area. I have been ordered attorney's fees in issues of discovery violations and sanctions, but that's not what you're asking. And I'm familiar with the statute. We've not had to weigh into that issue yet, though. By statute, will the courts do hearings for 17-year-old children who continue to need guardianship into adulthood with delayed effective order upon their 18th birthday? Ooh, I wouldn't think so. I would think that you would have to still uh, uh, petition the court uh, for permanent guardianship beyond the time the ward is 18. You can stay in the same probate court, and they often convert guardianships over minors to guardianships over adults. So you wouldn't have to necessarily file another petition. I believe you would have to have a hearing for continuation of it if the only um, uh, disability that the child had was their minority. That is specific in the law. That if a child becomes the age of majority and their only disability was they were a minor, then that would be a natural point that a guardianship would terminate of its own terms. When the ward has an intellectual disability and lives with parents, who is the petitioner? Are there issues with parents accepting service for the ward? Well, so the petitioner would be the person who is going to be the proposed guardian, right? So if you have two parents, there are circumstances where one parent is going to be the guardian and one parent is not going to be the guardian. We see that frequently in circumstances where perhaps not in a situation with a minor child, but with an adult. You cannot have a guardian who is also paid to provide home and community based services to an adult. So if you have two parents living at home, one parent is a guardian, another parent might be paid to provide home and community based services to the proposed ward. In that case, you would have the the one parent who wants to be the guardian be the petitioner. Could you then serve the other parent? I believe you probably could if the person is a minor, but if the person is an adult, you have to serve them individually, and I don't believe you'd be able to accept it on their behalf. Are there issues that arise when they accepted service? I mean, the good dose of medicine is to uh, make sure your T's are crossed and your I's are it dotted, that it was actually physically delivered to the individual, whether or not it's accepted by the parent. Um, if it's a minor, I don't see an issue with the parent accepting service. I think that if I were reviewing court, and there's probably a good reason I'm not, I would, if the parent is accepting service, I just absolutely would want the proposed ward to come to the hearing if appropriate. Okay. One thing that requires court approval and does so by a separate statute entirely is institutionalization. Okay. Uh, you cannot, unless it's in the state hospital, institutionalize a ward, or unless the state institutionalizes them, such as in the state hospital. Uh, there's no good standard for it, right? And so the court just has to give permission for institutionalization. It has to be in a suitable interest for treatment, or sorry, suitable institution for treatment, care, or safekeeping. So we don't have any really great guidance on what you really have to show in order to institutionalize someone. You just really have to get the court's permission before you do it, as a matter of caution. That's something, again, that we see, that a lot of guardians who we have interacted with do not know and have not asked court's permission before uh, institutionalizing their ward, that I think would be a great topic to ensure that they are aware of. What does it take to remove a guardian? Now, I want to differentiate this from termination of guardianship, right? A guardian can be removed or a guardianship can be terminated. This is not saying that somebody might not need a guardianship. This is saying that the person who is the guardian is no longer going to be guardian. Uh, it references the statutes with regard to personal representatives in the probate code. If the guardian becomes mentally incompetent, they didn't change that one when they changed the guardianship code to incapacity. Not sure if that has the same definition as the definition of incapacity in the guardianship code, but the one that's in the personal representative section says mentally incompetent, disqualified, unsuitable, or incapable of discharging his or her trust, if they have mismanaged the estate, if they have failed to perform any duty imposed by law or by any lawful order of the court. That might mean something so simple as the failure to file an accounting or the failure to file an inventory. Um, has ceased to be a resident of the state without authorization. Um, the court has to know if you are leaving its jurisdiction, right? And that's important because there are specific rules that apply to people from another state who are guardians of wards who live in our state, right? We have to be able to serve them. The ward has to be able to serve them. The court has to be able to um, ensure their presence before the court if need be. And so they have to establish, um, uh, sometimes the clerk as the proper party to be served to get notice then to the guardian. It's interesting. Something's only come up once in my experience. So it's not something we see terribly often, but I can see it happening a lot around the edge of the state, in Texarkana, Fort Smith, etc. As opposed to just removal of the guardianship, termination of guardianship. Guardianship is not going to exist anymore. That can be it has to be two elements, right? If the guardianship is not necessary anymore and guardianship is no longer in the best interest of the ward. It separately states that the court should adjudicate the ward's competency. And this other statute, we have 401 that talks about termination of guardianship. We have 402 that talks about what happens when the individual has their capacity restored. Perhaps their mental illness has been ameliorated or reduced. Perhaps their physical infirmity has been cured. Perhaps they just no longer need a guardianship because they have capacity. So this one's interesting because it expressly allows any person to allege that an individual has capacity by petitioning the court. Used to require an affidavit, and I believe that's one of the changes that happened in the current legislative session, that it might not anymore. One of the changes that did happen in this last legislative session to this statute did change this second point on the slide. Now, the court has to conduct a hearing after notice to determine whether the guardianship should be terminated or amended. The previous law, the one that, is still in effect today, but will no longer be in effect in about a month or so. The previous law that said the court shall cause the facts to be inquired into in such manner as it may direct, which is very interesting in practice. Now, it gives you a bit more of an idea of the things that the court will consider. Again, some states have gone through more guardianship reforms than we have. We've gone through quite a bit ourselves. Some of them have made guardianships more difficult to get. I think that our law, it requires clear and convincing evidence as the standard of proof that an individual needs a guardianship and is capacitated. That is a pretty high burden to meet. Our requirements for evaluations are excellent as long as they are adhered to. Requiring an understanding of an individual's IQ and adaptive behavior is something that doesn't exist in every jurisdiction. Appointment of counsel would be a great addition to the law, providing some guidance to courts on when appointment of counsel is appropriate, who can be appointed counsel, etc. There are some Title II implications, somewhat in some of the guardianship code, particularly with regard to the institutionalization section. It does require court approval beforehand. So if not sought, that could implicate some anti-discrimination issues. So yeah, I did make it through the guardianship section. Well, not quite. I'm almost there. Back to the continuum decision-making supports. We talked about guardianship generally and a lot about permanent plenary guardianships. I do want to talk a little bit about limited guardianship. So the state law description of guardianship doesn't really provide a lot of guidance on when a limited guardianship ought to be necessary or when a plenary guardianship is more appropriate. It just says if the court determines, right? And so each court might have its own standard to consider. The court has to state the specific powers and authorities that the duties of the guardian shall possess. That means if we're not going to do a plenary guardianship, there really is the requirement that the court has to specifically say what the guardian is going to have control over. Or in the alternative, they may grant a plenary guardianship of the person that is limited by expressly stating the powers or rights that the person may exercise without the intervention of the guardian. And we do have some questions. Who would pay for counsel, petitioner, use public defender? So, well, typically in a guardianship, we see that if a guardianship is ultimately granted, the counsel would be paid out of the estate of the ward, if they can afford it, obviously. There are some circumstances in which there is not an evaluation. A ward can ask the court, hey, you can tell the court, I've not been evaluated. Order an evaluation for me. The court can order the guardian to have the ward evaluated, and then at that point, basically, the petitioner, the guardian, would bear the cost of the evaluation if the ward is found not to require a guardianship. Vice versa, if the ward is found to require a guardianship. So, yeah, in that circumstance, we've seen that in practice a couple of times where somebody has not had a valid evaluation on the front end, and in that sense, the court may award the cost of the evaluation, essentially, or require the guardian in that circumstance to pay for the evaluation if they aren't entitled to a guardianship at that point. But who would pay for counsel? Usually it ends up being the ward if guardianship is granted. I've not seen a circumstance in which a ward has retained counsel and had a guardianship granted and their lawyer had to be paid for by the petitioner. I've not seen many circumstances where the petitioner has had to pay for the counsel who gets the guardianship, unless there's been some circumstances where there's been removal. So back to the continuum of decision-making supports, making our way through a little bit. We have representative payee. So this is a designation through Social Security. It's less restrictive alternative than permanent plenary guardianship. They act kind of like a guardian of the estate, but a limited guardianship of the estate, only over Social Security funds. You're not required to be a guardian in order to be a representative payee, but you have very similar reporting requirements. You have to do an accounting to Social Security. You have very specific responsibilities to make sure that the ward has a roof over their head, access to the services that they need, etc. And Social Security's audit requirements and their oversight tends to be a bit more stringent than what might be required by accountings that the court provides. So oftentimes we will see people kind of cede guardianship of the estate to representative payees, including we've seen the Office of Public Guardian frequently remove themselves of guardianship of the estate, or ask the court to remove them as guardianship of the estate when the individual only has Social Security funds as income. That's their only source of property, is through Social Security income, due to the oversight of Social Security and their reporting responsibilities. One of the questions, is it ever allowed to utilize medical records without a formal evaluation for a temporary guardianship? For a temporary guardianship, I don't know that would be that would be a problem. The problem might be accessing those medical records if you do not have authority to do so, perhaps, but that's not your question. But utilizing medical records, right? The bar is going to be lower for a temporary guardianship, right? Because it's not going to be long term. The court's going to have a hearing again. The court, you would have to go to court in order to request it to be permanent. But overall, for a guardian, what we see a lot of times is somebody will get an emergency guardianship, right? And that will last a period of time before there's a hearing. When the temporary guardianship hearing happens, they present evidence that they need a temporary guardianship. And then during the course of that temporary guardianship, we will see them get the award evaluated for a permanent guardianship at that time, and then provide the requisite evaluations to establish a permanent guardianship. What are the top three things a legal practitioner should assess before recommending guardianship as a solution for their client or their client's family member? One recommendation. Well, there is a great tool that I will give to Megan to send out to the participants that is just about talking to. It's the lawyer's tool for uh, uh, assessing guardianship and how to talk about guardianship with your clients. And it's got a great. It's called a practical tool, I think, for lawyers, um, and it talks about what are the area very things the statute says. What are the areas that assistance is needed? Right? Do they need assistance in doing everything? Um, do you know what less restrictive alternatives are available? Can we accomplish the goals with something that doesn't require you to petition the court and go to court and file accountings every year? Can we achieve your goals with a power of attorney, a surrogate decision maker? Do we need something that is legally enforceable, or does the person just need help understanding things and we can get by with a supported decision making agreement that the person can buy into? Do we need a psychiatric advance directive? Uh, does the person just have Social Security funds and they're able to take care of themselves otherwise? Can you be a representative payee? I think that's very important, is making sure that we're not jumping straight to let's go to court, let's get this finalized, and this way we don't have to visit it again. We can just get a total permanent guardianship. And what we see a lot of times is folks undertake that without understanding all of the responsibilities that come with being a guardian, either of the person or of the estate. And so that's probably the third thing that I would recommend to folks, is talk to them about what a good accounting looks like that they have to do every year. Uh, Show them a very specific inventory that hasn't been critiqued by the or uh, uh, criticized by the court, right? Those can be very, very long and grueling documents, depending on what kinds of resources the person has. Talk to them about fiduciary duties, and what that means for them to take on as an obligation. So those three things. Um, what help do you need? Do you know the less restrictive alternatives? What are all of your obligations that you undertake as a guardian? Because it is a big responsibility, um, and it shouldn't be jumped into lightly. Again, the continuum decision making uh, decision making supports psychiatric advance directive. This really is a form of a surrogate decision maker, or a durable power of attorney, or a springing power of attorney. It's a way to document a person's specific instructions or preferences about future mental health treatment. This is something that has really taken on regarding or really taken off in a lot of jurisdictions. We have the ability to do this in Arkansas. um, Lets the person prepare for the possibility that they may lose capacity to give or deny informed consent on paper, um, for later on. Lets them decide who they want to be their guardian, which the court should consider very carefully when person who has capacity is expressing their decisions beforehand about what they want to happen later. Um, we have an actual form of the Psychiatric Advance Directive. I believe we have it on our website, but if you all will email me, I can send you an example Psychiatric Advance Directive. Was that this person's question? It says, "Do you have a sample of that plea?" This isn't a pleading. This is going to be this is going to be kind of like a power of uh, an advance directive. Uh, but I can provide a copy of that if that's what you meant by, do you have a sample of that pleading? And what are the laws concerning guardians obtaining medical records, commissary, and belongings from a jail? I don't see why you wouldn't be able to do that, and the court ought to be able to back you up on that. I'm not familiar with any laws, one way or another, control whether a guardian can get access to belongings from a jail. When you're talking about getting access to medical records, I mean, there is a law that I believe it's in the guardianship code that you're acting in the shoes of the individual. So if the individual can access something, you ought to be able to access it as their guardian, especially if it's something so important as medical records. And if you cannot, for whatever reason, then I do not understand why a court would not be able to order the jail to provide you with those medical records, or the hospital to provide you with those medical records. On the site, back to the slide, uh, important concepts for a psychiatric directive, psychiatric advance directive. It is a form of informed consent, right? It's their way to exercise the consent and understand what they are uh, uh, possibly going to experience beforehand. It lets them buy into their mental health treatment in a future date, and it lets them express their right to refuse particular types of treatment, or say they don't want to receive particular types of medication because it does not affect them very well. Maybe they have a bad reaction to particular types of psychotropic medications. It allows them to have more buy-in to their mental health before they experience a crisis, and so is a great way to ensure their participation beforehand. You have to have capacity in order to complete it. Um, and it is a form of self-determination. It's exercising decision making beforehand. Let's see. More about psychiatric advance directives. This is the statute that authorizes psychiatric advance directive. Again, it is just an advanced directive, but it's specific to psychiatric care that we have developed a plan that is used in other jurisdictions very effectively as well. Let's see. Supported decision making. We do not have a supported decision making law here in Arkansas, which it means that it wouldn't be enforceable, but it doesn't mean that you can't consider a supported decision making agreement in concert with perhaps some other things to assist an individual with getting through the door. It is a way to support an individual in making their own decisions, as opposed to, say, a power of attorney, which grants decision making authority to another person, right? You're both able to make decisions for the individual. Here, the individual never gives up authority to make decisions for themselves. And perhaps with a power of attorney, since the individual can revoke that at any time, it might be very similar in nature, but with supported decision making, you never have given that authority over to another person. So there's less chance of an individual who is a supporter being able to make decisions on behalf of the individual because they haven't granted that authority to any of them or to anyone else. The supporter can help understand the issues and choices. We all use supported decision making to a certain extent when we ask questions of our bankers, our family, our friends, people with expertise in areas. So supported decision making is something that can happen across the board, and we ought to consider it for people who have incapacity that does not necessarily rise to the level of guardianship. There's no one size fits all approach to it, right? It could be really individualized. It's more of a paradigm than a process or a program. It's very hard to really draft up a form for it because it can be different for every person who uses it. Um, it really focuses on what works for the person to identify the areas of which they need help and providing that help to them to understand the consequences of making a decision and to help them understand their options. Let's see. I might actually get through the end of this. Why supported decision making? People with greater, and this goes for guardianship as well. People who are able to make their own decisions can exercise more life control. They are more independent. They're more integrated in their communities. They're healthier. They're more likely, and this is not me saying this. This comes from numerous studies. They're better able to recognize and resist abuse, and they take more part in their health care. According to a number of surveys that have been conducted over the last 50 years, when denied self determination, people will describe the lack of self determination as making them feel helpless, hopeless, and self critical. They can experience low self esteem, passivity, and feelings of inadequacy and incompetency, decreasing their availability or their ability to function. And overbroad or undue guardianship can have a significant negative impact on physical and mental health, longevity, ability to function, and reports of subjective well being. So, not to say that guardianship has no place in society, but we do need to be cautious as a bar about whether permanent plenary guardianship and removal of all rights that an individual has from them before undertaking that act, because it does impact health, happiness, security, and an individual's ability to function. Um, uh, Usually results in decreased life outcomes and decreased health outcomes. Here's some resources. And then we have a new address. So we are the same address, but it's Suite 1500 in Little Rock still. If anybody has any questions or concerns after the fact, if I didn't understand your question, which is possible, or you have any more questions, I am open to that. Please reach out.
Thank you, Thomas. Did you want to answer this last question here, or do you want me to continue on?
In your experience, how difficult is it to get a petitioner who is a felon approved to also be guardian of the estate? There's a specific statute, you might know that, specific statute on qualifications for guardians. Ask the court's permission. I do not know how difficult it is. We don't get guardianships for people. We usually come in if the guardianship is abusive, neglectful, exploitative, etc. So how difficult it is to get a guardianship is not something I know. If it's an unpardoned felon, I don't remember what the qualification is for that because we don't see many instances in which somebody who has a felony on their record has been granted guardianship. I know there are specific laws on the unpardoned felon section of that statute, but that's in the qualification of guardians section of the probate code.
And thank you again, Thomas, and we all hope you have a great afternoon. Thank you.